Merci. Test Palais Wilson, ground floor. Pour le webcast, test Palais Wilson, ground floor. Est-ce que c'est bon pour toi? Canal anglais, canal 2.
Good afternoon. I call to order meeting number 42 of the 78th session of the Committee on Economic, Social and Cultural Rights. It is my great pleasure to welcome the distinguished delegation of the Netherlands, and in particular the head of the delegation, His Excellency Mr. Willem Geerts, Director of International Affairs, Ministry of Social Affairs and Employment, and of course the Ambassador PR is here as well, who will deliver the opening statement, and the distinguished members of the delegation of the Netherlands. A very warm welcome to you. I would also like to welcome all those observing this dialogue in person and through webcast. Before giving the floor to the delegation for the consideration of the 7th periodic report, I would like to outline the methodology we will follow for the dialogue today and tomorrow. We have prepared a sheet with the proposed speaking times, Your Excellency, as you're aware, for the dialogue, which will be conducted following the 4 clusters of our covenant and led by the committee members constituting a task force for this review. The initial questions will be posed by the country rapporteur and the lead member of the cluster, that is Articles 1 to 5, and that's Ms. Julieta Rossi. Other members may pose follow-up questions thereafter. Other members of the task force include myself for Cluster 2, which is Articles 6, 7, 8, and 9, Mr. Peter Zemuse, Cluster 3 for Articles 10, 11, and 12, and Ms. Laura Crachinyu-Tatu, who's in charge of Cluster 4, which is Articles 13, 14, and 15. The delegation is kindly requested to speak at a reasonable pace and to provide any written material that will be read out by the delegation to the Secretariat. To facilitate this process, enable us to cover the full range of issues at hand, I would like to invite my colleagues and the distinguished delegation to speak in a concise manner, giving due attention to both the time allocation, which is displayed in their monitor out there, as well as to facilitate our interpreters. So keep the pace at a reasonable level. With this, I have the pleasure to give you the floor, Your Excellency, to deliver your opening statement, and the delegation has 10 minutes for that. Thank you. You have the floor.
Thank you very much, Madam Chair, and thank you for welcoming me here in this beautiful building. Distinguished members of the committee, dear representatives of civil society organizations. Unfortunately, it was not possible for us to meet everyone in person before the meeting, but hopefully that will be possible later on. My name is Willem Geerts. I'm the Director of International Affairs of the Ministry of Social Affairs and Employment, and I'm honored to lead the delegation for the Kingdom of the Netherlands during this dialogue on our implementation of the Covenant on Economic, Social and Cultural Rights. We look forward to a fruitful dialogue and stand ready to answer your questions to the best of our abilities. I would like to start briefly by clarifying the constitutional structure of the Kingdom. The Kingdom of the Netherlands consists of 4 autonomous countries of equal status. Each country within the Kingdom of the Netherlands is autonomous in its implementation of the obligations from the Covenant. So that includes the countries Aruba, Curaçao and Sint Maarten, and the country of the Netherlands, which includes the Caribbean islands of Bonaire, St. Eustatius and Saba as special municipalities, which we together call the Caribbean Netherlands. Today, representatives of Aruba and the Netherlands are present to participate in this constructive dialogue. Unfortunately, representatives of Curaçao and Sint Maarten are unable to join us today. However, they have contributed to the written response to the list of issues which was provided to your committee last year. In respecting the autonomous status of each country, I'm unfortunately not in a position to answer questions relating to Curaçao and Sint Maarten during this dialogue, but we can pass these on to the respective governments if the committee so desires. It is my honor to introduce our delegation. The country of Aruba is represented by Mr. Xavier Similaire. He will speak later on in the opening statement. And I'm representing the country of the Netherlands together with a delegation from across the Dutch government who's sitting in the middle of the room. Any questions related specifically to Aruba or the Netherlands will therefore be answered by a representative of that country. I would now like to deliver some introductory remarks on behalf of the Netherlands, following which Mr. Similaire will speak on behalf of Aruba. Our delegation includes experts from the Ministry of Social Affairs and Employment, Interior and Kingdom Relations, Justice and Security, Asylum and Migration, Health, Welfare and Sport, Education, Culture and Science, and Foreign Affairs. Over the next 2 days, you will be hearing from my colleagues directly on their areas of expertise. I would like to take a moment to explain the current political situation in the Netherlands. We currently have a caretaker government pending parliamentary elections that will take place at the end of next month. Under our constitutional convention, the caretaker government only acts on urgent matters, with other decisions being deferred until a new government is in place. We value the way we have implemented economic, social and cultural rights in the Netherlands. At the same time, we are keenly aware that these rights must be constantly protected and strengthened, which requires our continuous attention. This dialogue with your committee helps us to reflect on our policies and to keep ensuring these rights. In preparation for today's sessions, we've had fruitful conversations with our National Human Rights Institute, trade unions and civil society organizations. This constructive dialogue allowed our government to engage deeply with the issues relating to the effective implementation of the Covenant. I highly appreciate the presence of the chair of our National Human Rights Institute, Professor Rick Lawson, and other civil society representatives during this dialogue, and others will be monitoring proceedings online. To us, this serves to further underline the value of the dialogue with your committee. And of course, your committee's concluding observations and recommendations will serve to further inform conversations between the Dutch government, parliament, and civil society organizations. Looking at the time, I will highlight some recent developments in relation to social, economic, and cultural rights in the Netherlands. I would like to start with a reflection on the impact of COVID-19 on health and employment. Throughout the pandemic, the Dutch government placed the highest priority on the protection of public health. We implemented restrictions on daily life to protect the most vulnerable and worked at pace to ensure vaccines were accessible to all. Faced with unprecedented challenges and restrictions, the Dutch government embarked on a comprehensive effort to support workers and businesses. These measures limited the impact of the pandemic on employment rates and protected livelihoods. Although the employment rate did climb somewhat during 2020, it returned to pre-pandemic levels by the end of 2021 and has remained below 4% since then. Secondly, like many countries, the Netherlands has in recent years faced high levels of inflation, which have affected the cost of living. This particularly affects low-wage workers and recipients of benefits. I'm pleased to mention that to protect this group of people, the Dutch government has increased the minimum wage. Since July 2020, for full-time employees, the minimum wage has risen by 28% and 42%, depending on the number of hours worked per week. Additionally, the government has taken steps to make childcare more affordable for families with young children. Such policies provide much-needed income security to those who otherwise could struggle to make ends meet. Our investment in tackling poverty is showing results. In recent years, the number of people in the Netherlands struggling with poverty has fallen from over 7% in 2018 to 3% in 2023. But our work is certainly not done, and we have recently launched a national program on poverty reduction to help more people out of poverty. Thirdly, the Netherlands acknowledges that certain groups of migrant workers are underpaid and live in substandard conditions. Therefore, we are taking significant steps to improve their economic and social rights. The government commissioned an independent review of their situation and is working to implement the recommendations. One key recommendation was the establishment of an admission system for temporary employment agencies to ensure these agencies comply with Dutch law. When this legislation enters into force in 2028, it will be enforced by the Netherlands Labour Authority. Furthermore, a new bill aims to provide greater control over how much, where, and for whom housing is being built. With the enactment of this law, municipalities will develop a public housing program, which must also specifically address the housing needs of targeted groups, such as migrant workers. In addition, the government is preparing a bill to ensure better rent protection for migrant workers. And we have opened physical and mobile information points throughout the country for them. Fourthly, and my last point, I would like to highlight the ambition of our social security reform agenda. The Netherlands has a comprehensive and general social security system. At the same time, it has grown increasingly complex over the past years, and this has led to negative impacts for citizens. Over the last decade, a childcare benefits scandal was uncovered. Parents or caregivers had their childcare benefits unjustly cancelled. Rules were applied in an excessively strict manner, and benefit recovery policies, including systems, later found to contain elements of institutional racism. In 2022, the government launched a major operation to provide victims with fair compensation and assistance. As well as addressing past wrongs, the government has launched a reform agenda to ensure that benefits provide income security, the system is easier to understand, and more work should lead to more pay. In this way, the government the government implements a more human-focused approach to our system of benefits instead of a focus on strict rules. Parliament is currently considering new legislation to create a right to make a mistake in benefit applications. These examples serve to underline our efforts, but certainly also the challenges we've been facing. And together they show our continuing commitment to implement the provisions of the Covenant. Madam Chair, distinguished members of the committee, we look forward to engaging in an open dialogue on economic, social and cultural rights in the Netherlands. And now I would like to give the floor to my distinguished colleague from Aruba.
Distinguished Chair, members of the committee, representatives from civil society organizations, and colleagues. On behalf of the government of Aruba, it is my pleasure to present introductory remarks to this dialogue. The International Covenant on Economic, Social, and Cultural Rights holds special meaning for Aruba, being among the first conventions for which Aruba assumed responsibility as an autonomous country within the Kingdom of the Netherlands on January 1st, 1986. Next year, we will mark 40 years of autonomy, and with it 40 years of direct responsibility for upholding the rights established in the Covenant, a testament to the will of the Aruban people to shape their own social, economic, and cultural development. A key institutional development has been the appointment of Aruba's first ombudsman in October 2024, strengthening accountability, good governance, and the protection of citizens' rights. Aruba has also taken important steps to reinforce child protection, including training more than 300 professionals in the science of safety approach and introducing a child safety code in 2021, which mandates reporting of abuse and neglect across sectors. The Promotion of Continued Parenting and Careful Divorce Act further safeguards children's interests during family transitions. Preventive and cultural measures have likewise advanced. With UNICEF Netherlands technical support, Aruba has launched in 2024 a national vision on parenting support and a social map of agencies assisting parents, framed by a theory of change developed with broad stakeholder input. In the field of cultural rights, Aruba has prepared a national plan for culture and arts education under the UNESCO framework, linking local history and papiamento to formal education. Aruba remains mindful of the challenges ahead, but steadfast in its commitment to protecting human rights. We look forward to this dialogue and to the committee's views and recommendations. Thank you.
I thank the distinguished delegation of the Netherlands for their opening remarks. And I will now request the country rapporteur, Ms. Julieta Rosen, to kindly take the floor and pose her questions on articles from Articles 1 to 5. You have the floor, madam.
Gracias, señora presidenta.
Thank you, Chair. I would like to extend a warm welcome to the distinguished and large delegation of the Netherlands, made up of the countries of Curaçao, Aruba, St. Martin, and the Netherlands. I would also like to extend particular greeting to Mr. Bertz from the Ministry of Social Employment, head of delegation. I have been appointed country rapporteur, and along with my colleagues, Madam Saran, Mr. Peters Mules, and Ms. Laura Maria, we will be asking questions, hoping to guide the constructive dialogue we have ahead of us tomorrow. The goal of this dialogue is to identify challenges, structural difficulties that the country is facing in order to properly meet with the obligations of the Economic, Social, and Cultural Rights Covenant. And we will have then recommendations that we hope will be borne in mind and implemented in good faith by the state to guide legislation and the creation of public policies and programs nationwide. I will begin with Group 1 of rights. They cover Articles 1 through 5 of the Covenant, after which my colleagues from the working group will ask questions under Cluster 2, Articles 6 through 9, Group 3, Articles 10 to 12, and the last cluster, number 4, covers Articles 13, 14, and 15. Beginning with the report of the state party and the reply to the list of issues, as well as information provided by civil society organizations, the National Human Rights Institute of the Netherlands, and other interested parties, I would like to ask the 8 following questions, hoping that the delegation will provide additional information or clarifications. And some of these questions have sub-questions within them. After that, I will have even more questions in the follow-up section. So I'll begin with cross-cutting or general questions, if you will. On the internal application of the covenant, I would like to point out the previous recommendations the committee had 2010, 2017. And then with those recommendations in mind, I would like to ask detailed information about what the state has done in order to fully include the rights recognized in the covenant in your domestic legal order, and to ensure that they are taken into account whenever drafting policies and laws, and in cases brought before the justice courts throughout the kingdom's court. And the following statement is found in the report. The covenant does not impose on state parties the obligation to concede people rights that they might bring before a court, given that this runs counter to the provisions of the covenant and its consolidated interpretation. How can you explain that statement? Please also inform us about measures taken to reduce disparity in the implementation of the covenant in the various countries, mainly between the European territory of the Netherlands and the Dutch Caribbean. Also, please inform us of the process for the ratification of the optional protocol to the covenant, bearing in mind that you ratified it many years ago in 2009. On national human rights institutions, please let us know whether the mandate of the National Human Rights Institute extends to the Dutch Caribbean islands, and what is the regulatory framework of action? Does it include economic, social, and cultural rights and the presentation of individual complaints in these territories? Please inform us as well whether the financial resources allocated are enough for it to properly fulfill its mandate, particularly in the Caribbean. Also, please inform us whether you have met the recommendations of GONRE and what was done in establishing a national human rights institution in Curaçao and St. Martin. On businesses and human rights, please inform us on progress made in including in the domestic legislation the EU guideline on due diligence on business sustainability, as well as the position taken by the state party regarding the proposed reforms of this guideline within the Council of Europe, the directive of the Council of Europe. And please inform us of all binding measures for public and private businesses under the jurisdiction of the state party with the guiding principles of business and human rights of the United Nations, with a focus on the specific legal obligations of businesses operating overseas. Please provide information, up-to-date information about the implementation and the results of the National Action Plan 2022-2026 and the monitoring and transparency mechanisms that have been used. On climate change and the environment, that's the next question. Official reports say that the government or the state is currently not meeting the greenhouse gas reduction goals established in the nationally determined contributions as part of the Paris Agreement, and that recent changes to policies, such as the postponement of climate measures, make it even less likely that these goals will be reached. Please explain why is this so, and what do you plan to do to achieve the goal? The committee is concerned about the Caribbean Netherlands and how particularly vulnerable it is to climate change, as the state itself recognizes. The climate and environmental frameworks based on human rights are still in the development phase, and they do not ensure protection equivalent to that afforded European countries. Please inform us about this. How is the government assessing whether their environmental and climate-related policies provide proper protection to the rights of the people at greatest risk, and they ensure fair, equal distribution of the benefits and the burden throughout the kingdom? Please provide details about measures adopted in order to materialize the guiding principles set forth in the Paris Agreement about common but differentiated responsibilities and respective capabilities, and how is it used specifically and in general with the Caribbean Netherlands in terms of cooperation and technology transfer and financing for a fair transition, and also about reparations. Please inform us about measures adopted to face natural disasters and extreme weather phenomena in the territories of the Caribbean Netherlands in particular. Also, please provide information on the question presented, the demand presented by the residents of the island of Bonaire, where they're asking the courts to force the government to reduce greenhouse gas emissions in order to meet its fair share and to protect the residents of the island that barely produce any greenhouse gases at all and are increasingly affected by climate change. A scientific research of the Free University of Amsterdam says that energy measures need to be adopted in order to avoid serious consequences in this island, because part of it will be underwater by 2050, according to information. Please provide information on the broader environmental challenges, problems with waste management that exist for a while in Bonaire. Following up on the recommendation of the committee from 2019, please inform us as well on the restructuring of the oil refinery industry in Curaçao to curb environmental pollution and harmful effects to the population's health. In this regard, please tell us whether the air quality standards in Curaçao are in line with those of the World Health Organization and whether it has been decreed by law. If so, then please tell us about their implementation and creating a air quality control network. How does the government guarantee equal and proper protection of environmental rights in the Caribbean Netherlands, both legislation and in practice? On matters related to provisions 1 through 5 of the covenant, beginning with the maximum available resources. Information that the committee has received points to wealth being rather concentrated in the Netherlands. The committee then requests information on financial measures that have been adopted that are even more progressive, or that you plan on adapting, that are more progressive and that would tax people in proportion to their wealth, particularly those with greater wealth. And also plans on increasing inheritance tax and reducing indirect taxes such as value-added tax. Also, according to the Tax Justice Network, Netherlands is 7th in the corporate tax haven list drafted by that organization. Please tell us about measures adopted by the government to face tax evasion and illicit financial flows. Also, are there public assessments on the loss of resources due to tax evasion, the tax burden of them, and its impact on available resources for economic, social, and cultural rights in the territory of the state party, as well as extraterritorially, particularly in developing countries? On the budgets, please tell us how you guarantee that it is transparent and that everyone participates in their drafting. Also, provide information on budgetary measures and other types of measures taken to face difficulties faced by vulnerable groups in the European and Caribbean Netherlands. Current resource allocation has not bridged the social security gaps or housing and environmental protection gaps, particularly between the territories. Regarding non-discrimination, according to recommendation 19 of the concluding observations of 2017 from this committee, please inform us on assessments done by the systematic structural causes of discrimination against disadvantaged groups, such as ethnic minorities, migrants, refugees, and asylum seekers, persons with disabilities, women, LGBTI+, and the Roma and Nomad populations, and special temporary measures that you're adopting in order to overcome the de facto discrimination experienced by many groups. These groups, in particular as regards employment, social security, health, housing, do you have policies and programs aimed at combating prejudice and stigmatization of members of these groups, in particular refugees. We would like to ask for information on the bill that seeks to penalize migrants in an irregular situation in the Netherlands and prohibit municipalities from prioritizing refugees and granting social housing, given that these are regressive and discriminatory measures with negative impact on the prevention of human trafficking and labor exploitation.
Lastly, please tell us about the measures adopted and their impacts to overcome structural barriers which prevent people in the Caribbean Netherlands in accessing rights on an equal basis with those living in European Netherlands. And lastly, on equality between women and men. There's still a salary gap between men and women, despite the EU directive on wage transparency. In 2024, it fell to 10.5%, but it is still high. So what measures is the state party taking and to implement the EU directive? Furthermore, there is a huge discrepancy in the amount of people in part-time work between the sexes, 63% of women versus 23% of men, which affects women's economic independence. There's also discrimination against pregnant workers. So what measures are you taking to overcome these situations? Now, with regard to women's representation, whilst you have brought in quotas to get gender equality in company boards, those quotas have not yet been fulfilled. We've also heard that policies to reform parental leave have been insufficient to redistribute domestic and care responsibilities. They continue to be borne primarily by women. Please tell us in general terms about measures taken to address this situation, their impact, as well as special temporary measures with a view to achieving substantive equality. Could you also tell us about progress made in gender equality in the islands of the Caribbean Netherlands? I'll leave it at that for now, but I reserve the right to take the floor again to ask further questions during the next segment. Thank you very much for listening, and I'm sure that you'll be ready to answer now. Thank you.
So we will just take a 2-minute break for the delegation to organize its work. I request committee members to kindly stay in the room so that we can proceed immediately thereafter. Just 2-minute break. delegation and the other members of the delegation to kindly respond to the questions posed by Ms. Rossi. Your Excellency, the delegation has 30 minutes to respond. Thank you.
Thank you very much, Madam Chair, and Madam Rossi also for your extensive list of questions that we'll try to answer to the best of our abilities. Let me start. Maybe one point in advance. I heard you mention a few questions regarding the country of Curacao. As I tried to explain in my opening statement, the representative of Curacao is not there, and in our constitutional structure, I'm not mandated to answer on their behalf, but we will certainly inform them of your questions, and if there's any way that we can ask them to provide further information that would be welcome to you, we're certainly happy to facilitate that. I will try to answer several questions and then ask my colleagues to follow up on their areas of expertise, and then we'll see at the end how far we've got and if we have missed maybe in the speed one or two questions. I think your first question was, I think, a wider question relating to the way the economic, social, and cultural rights are integrated in our domestic legal order. And you did quote from our report where we have explained that in the view of our country, well, let me first say I will not try to repeat everything that we said in that written statement. I think the brief version is that this is still the way we look at the way the covenant and our domestic legal order are related, and this is briefly to say that if the Constitution contains a specific article regarding the justiciability of provisions of international law, someone, so a citizen, can invoke a provision of international law before domestic courts when that provision is binding on all persons. And in our system, it's up to our domestic courts to determine in specific cases whether such a provision is indeed binding on all persons. And if that is the case, they can directly apply the provision of international law. So in reality, so far, the application of economic, social, and cultural rights by domestic courts in the Netherlands is scarce. So Dutch courts generally consider the provisions of the convention of the covenant not to be binding on all persons, referring to their general wording, nature, and scope. But I would like to stress that, of course, that does in no way does that lead to the conclusion that we don't want to or are not actually implementing these rights in our national domestic order. So I would say in the Netherlands, we have a growing emphasis on ensuring meaningful compliance with economic, cultural, and social rights. In all cases, the legislative and the executive branch are, of course, bound by these rights. And accordingly, economic, social, and cultural rights are taken into consideration during the legislative process. They are incorporated into manuals used in policymaking and legislative processes. And an example of that is the policy compass that all Dutch civil servants use when they are drafting new legislation. Furthermore, during this process of drafting legislation, Department of the Interior and Kingdom Relations and the Department of Justice and Security do a specific check on economic, social, and cultural rights. So we are currently reinforcing this structure to better support compliance with these rights. And for example, we are currently working on an internal manual on constitutional review that we are updating, placing particular attention on strengthening the assessment of compliance with ESC rights. I do acknowledge that this does not fully answer the request you're having to us, but this is the way our structure is working right now. And to our assessment, we are living up to our obligations on the covenant in that way and giving it a real meaning in our national domestic constitutional system. I would like to continue with your question on the optional protocol. In 2023, the Dutch government reviewed the ratification of the optional protocols for the 3 different human rights treaties. So also the Convention on the Rights of Persons with Disabilities and the Convention on the Rights of the Child. And at that moment, the government decided to ratify the optional protocol to the UN Convention on Disabilities. So we're currently preparing that ratification. because it aligns with the development of a multi-year national strategy for this covenant that we are working on. We have decided to first learn from the experience of working with the CRPD protocol before taking a decision on further ratifications. So for now, we have not decided to ratify the protocol to the ECSCR. If you want, I could go in more details later on if you want some more information on that process. But that is the current status of the decisions within the government. I will later ask. We're not going to follow your questions in the exact order. I will take a few questions within my mandate and then ask colleagues to follow up on other areas. So you were referring to the Dutch climate policies. I would like to reiterate that we are fully committed to the international agreement, of course, the Paris Climate Agreement, but also the EU legislation that we have implemented within Europe to ensure that will be meeting these targets. As I said, I'm currently having a caretaker government. It's not within our position right now to introduce new proposals, but I'm sure that the next government will continue to be involved in making decisions about how to live up to these commitments. You asked the questions about the way we are adapting to climate change, both in the Netherlands and the European Netherlands and in the Caribbean Netherlands. Our first Dutch national adaptation strategy was released in 2016. And after that, we have launched an implementation program, NUPCA, in 2023. Since early 2024, we have been working on reviewing our national adaptation strategy, and we expect the next iteration to be published in 2026. And importantly, this will be a whole of government strategy in which the Caribbean Netherlands, so Bonaire, Saba, and Saint Eustatius, will be an integral part. We are currently working on the environmental impact report and the social impact analysis. And I would especially, perhaps this last element, so the social impact analysis will chart the expected also the social effects of climate adaptation measures. And of course, we are making a point of introducing proper participation processes, including ensuring the involvement of young persons in the policy-making process. Let me briefly see if I'm missing something important here. Yeah, you were asking also about extreme weather events. Of course, these elements are also a part of these adaptation strategies. In the Netherlands, we have coded warnings from the National Meteorological Institute and the Public Health and Environment Institute. And the implementation of these policies is not done just by the government at the central level, but also by municipalities and by the water boards. I don't have exact answers right now on the questions you were asking about the situation in Bonaire, but if necessary, I would like to come back to that on a later moment in time. You have also asked a question on resources and fiscal measures. So there, I would like to say that in the Netherlands, so the European Netherlands, the country of the Netherlands, we are having a progressive tax system. So it's already the case that higher income is taxed more strongly. You were asking a question about the inheritance tax. There's no one of the Ministry of Finance present here, but to my knowledge, there's no proposal at the moment to revise it. But it is a discussion in national politics about whether it needs a revision. So that would also be something I think that the new government will take a position on. You have been asking also about our international tax policies and our fight against tax evasion. I would like to stress that the Kingdom of the Netherlands is an active and constructive participant in discussions on international reforms on tax policy, including in the UN, the OECD, the G20, and the European Union. And in that process, we try to take seriously concerns of developing economies and properly address international taxation policy issues and problems. So we have also we are still a constructive participant in the discussions on the UN Framework Convention on International Tax Cooperation. and we have supported the efforts within the OECD, for example, the base erosion and profits project, and the follow-up international standard that is being developed on that basis. So we try also, not just at the national level, also at the international level, to be a responsible partner in that field. Okay. I would stop here and ask my colleague for the Ministry of Foreign Affairs to follow up on the questions, including, in particular, I think, on due diligence and related questions. Yes, thank you.
Yes. Good afternoon. My name is Marina Brilman from the Foreign Affairs, Ministry of Foreign Affairs of the Kingdom of the Netherlands. I will address the questions relating to business and human rights. Thank you very much, distinguished committee member, for those questions. Starting with the advances to implement or incorporate CSDD international law. The Omnibus 1 proposal of the European Commission, of course, includes amendments to the CSDD, as well as an extension of the implementation period of 1 year. Following this proposal, the EU agreed on the Stop the Clock Directive, which extends the implementation deadline to July 2027. The Council of the EU agreed on a negotiating mandate for the omnibus simplification of the CSDD, which also extends the implementation period. And as such, the European Parliament is expected to reach a position on this as well. So the precise content and implementation timeline of the CSDD is not yet clear. However, the Netherlands will continue its preparatory work on the national law on responsible business conduct, de Wet Internationaal Verantwoord Ondernemen, regarding parts that are not affected by the proposed amendments in the omnibus. And once an agreement on the amendments has been reached within the EU, the Kingdom of the Netherlands will continue the legislative process for transposition of the CSDD into national law. The proposed supervisory body to monitor and enforce the implementation of this law will be the Authority for Consumers and Markets. With regard to the question, what position the Kingdom of the Netherlands has taken with regard to the suggested amendments suggested by the European Commission. In general, the Kingdom of the Netherlands welcomes the efforts to simplify the CSDD in order to alleviate administrative burdens. However, the Netherlands has sought to clarify certain open norms, for example, the duty to suspend business relationships and the new stakeholder definition, this to enhance legal certainty and to minimize room for differing interpretations among EU member states. The Netherlands has in principle supported the European Commission's proposal to limit due diligence to direct business partners because of the reduced administrative burden. But at the same time, the Netherlands has advocated for a more risk-based approach in line with international standards on responsible business conduct. The Netherlands supports the European Commission's proposed simplification of the climate transition plan obligation. But for the Netherlands, it is important that the obligation to adopt a climate transition plan is maintained. And the Netherlands has not supported the Commission's proposal to remove the harmonized civil liability regime from the original CSDD. With regards to the question on measures taken with a focus on business activities also extraterritorially, the Netherlands expects all businesses operating in or from the Netherlands to implement the OECD guidelines and the UNGPs. And it expects businesses to identify risks of contributing to human rights violations or adverse impacts due to their activities and in their value chain. Under the CSDD, companies within its scope will also be obliged to conduct due diligence. The Netherlands will, as said, transpose this directive into national legislation other EU legislation with a due diligence component, such as the forced labor regulation, the deforestation regulation, the corporate sustainability reporting directive, and the conflict minerals regulation, have been or will also be implemented. In addition, in terms of improving access to an effective remedy, an example of a concrete measure that the Netherlands has taken is to improve access to judicial mechanisms by monitoring access to Dutch law by foreign rights holders. More specifically, the Netherlands conducts annual monitoring of the so-called settlement of mass damages claims in collective actions law, the WAMCA, Wet Afwikkeling Massaschade in Collectieve Actie, which entered into force in 2020. And this act makes it possible to settle damages collectively in joint proceedings, so that groups of victims of human rights abuses caused by businesses operating in or from the Netherlands can use this law, making it unnecessary to litigate individually to claim damages. In addition, when businesses do not observe their responsibilities in the context of the OECD guidelines, this may lead to the withholding by the Netherlands of the provision of trade and investment services. And the Netherlands Enterprise Agency, which is a government agency that falls under the Ministry of Economic Affairs, conducts checks, also by means of random sampling, or assessments based on risk profiles to monitor whether companies are complying with their responsible business conduct conditions. Although primary focus is on raising awareness, if it is evident that a company is not adhering, it may result in support being withheld, terminated, or reclaimed. With regard to the plan of action, the National Action Plan, that was issued in July. The second one was launched in July 2022. It runs until 2026. There are 33 concrete action points, including timeline and monitoring. Progress is monitored by an interministerial working group, and an annual progress report is presented to Parliament. A draft progress report is presented every 2 years to a focus group, including CSOs, business community, and experts. And nearly all the actions set out in the action plan have been started or completed. A complete overview of the progress made can be found on Dutch government website. If information is required specifically on extraterritoriality and business activities with regard to the National Action Plan, we will kindly ask to get back to you with that information. And I would like to pass on to the next delegation member. Thank you.
Let's just check if you can hear me. Great. Thank you. And thank you to the committee for their questions. I'm going to speak to the questions about the National Human Rights Institute, measures against discrimination in a general sense, and also on the legislative proposal on the prohibition of priority of refugee residence permit holders. On the topic of the NHRI, a specific question was asked about the mandate of the NHRI with regard to the Caribbean parts of the Netherlands. The answer is yes. The mandate of the NHRI, or the NHRI, has a mandate to investigate and to give advice on human rights, including economic, social, and cultural rights, and that mandate also extends to the Caribbean Netherlands. The mandate of the NHRI to give rulings about discrimination does at this point not extend to the Caribbean Netherlands, but a bill is pending before Parliament to expand this mandate of the NHRI to the Caribbean Netherlands. This is foreseen to commence in the first half of 2026, and the NHRI will receive a structural annual budget of approximately 200,000 euros for this expansion of its mandate. A question was also asked about the measures against discrimination. What I can share is that the Dutch government has published 2 national action programs on discrimination, one in 2022 and one in 2023. At this point, a third national action plan with a long-term agenda is being finalized. The national action plan covers all forms of discrimination in many areas of life. Discrimination of various groups in Dutch society are addressed in this program. The program is drafted by the National Coordinator Against Discrimination and Racism in cooperation with different ministries, and it contains analysis and measures, among them on tackling structural discrimination. After the program is published, the National Coordinator keeps record of the progress made by the ministries on different measures. A list with a score on the progress, as given by the National Coordinator, is then published with the national program. There was also a question with regard to the law on priority access for social housing for residence permit holders. The Dutch government is at this point working on a law that normalizes the position of residence permit holders in comparison to other people in need of housing. This means that resident permit holders can still get priority access to social housing based on acute needs, which is the case for all Dutch citizens. They can get priority access, for example, because of medical reasons. However, they will not get priority access based solely on the fact that they are residence permit holders. With this law, residence permit holders are, in the opinion of the Dutch government, treated equally as to other Dutch citizens. I will now give the floor to my next coworker.
Thank you very much. My name is Esther Meijer. I work at the Ministry for Asylum and Migration. And I will answer your question regarding a bill on irregular migrants. So there are indeed currently 2 draft bills regarding asylum, and these still need to be assessed by our Senate. So it's still pending and in process. So would like to underline that. So an amendment has been introduced to these bills during the parliamentary debate on the bills, which states that illegal residents would be criminalized if these bills would be approved. So this means that an adult third country national who resides illegally in the Netherlands would become liable to prosecution if residing in the Netherlands, while knowing that such a residence is unlawful and the period of voluntary return has already passed. And I think in this regard, it's very important to underline a few considerations also in relation to the rights of people without legal residency, as stated in the covenant as well. So there would be very specific restrictions to the scope of the criminalization of illegality. So this would only be possible after the whole return procedure has already been completed and departure has not been successful by fault of the foreign national, him or herself. Also, a very important condition is that return would not constitute a violation of Article 3 of the European Convention for the Protection of Human Rights. And also, last but not least, the criminalization of illegal residence does not affect the right to education for minors or the right to necessary medical care. So yeah, the draft bill and the amendment and the proposed revision of the amendment still have to pass through the upper house of parliament, and therefore this is all information we can currently provide. Now I would like to give the floor to you. Thank you.
I'm Poonam Brar. I'm from the Ministry of Social Affairs and Employment. I will answer the questions on gender equality. The efforts of the Dutch government to change stereotyped gender roles have been widespread and diverse. Because we want people to be able to develop and use their talents unhindered by stereotypes, and because of shortages on the labor market, the Dutch government wants to break these stereotypes. The government, for example, funds various alliances to break gender stereotypes in education and with regards to a more equal balance between work and care tasks between men and women. Various measures were taken to raise awareness on the possibilities to take up parental leave and share family responsibilities. In 2018 and 2019, the campaign Have You Guys Decided Yet? Ran, which was meant to foster a conversation on work and care responsibilities between expecting parents. Surrounding the introduction of paternity leave, geboorteverlof, for partners in 2019 and 2020, campaigns ran to inform people about the possibilities to take up leave through communication towards employers and employees. And in 2024, a campaign was launched that pointed out prejudices regarding the role of women and men at work and in family responsibilities. To enable parents to combine care for their children with paid work, a child care allowance is paid to working parents as a compensation in the cost for child care. In 2019, 23 and 24, the child care allowance was increased on top of the irregular indexation. The financing of the childcare system is currently being reformed with the goal of making it more affordable and easily accessible for most working parents. Since 2019, the parental leave arrangements have been expanded multiple times in the Netherlands, which contributes also to an equal division of care duties between parents. As mentioned before, in 2019, fathers obtained the right to 1 working week of paid leave after the birth of their child. In July 2020, partners gained the right to 5 additional weeks of partially paid birth leave. From August 2022, all parents, mothers, fathers, adoptive or foster parents, were additionally entitled to 9 weeks of partially paid parental leave. One of the objectives of these leave arrangements is to facilitate parents to combine work with care responsibilities, to enable partners to divide responsibilities equally, and to maintain long-term labor market participation. Recently, a first light evaluation of the paid parental leave was conducted. This showed that parents, employers are generally positive about the paid parental leave. One thing the evaluation pointed out is that parents do not oversee the leave system as a whole. This is something we are currently working on with the simplification of the leave system. In this process, attention will go out to the awareness raising regarding the combination of work and family life. Currently, a more thorough evaluation of the paid parental leave is being conducted. The results of this evaluation are expected in the beginning of the next year. Then about the financial independence, well, we think work is the most important step towards it, and that is why the Dutch government supports women who want to start work or work more hours. In the Netherlands, it's true, more women work part-time than men. The average number of hours worked by women has increased. In 2014, it was under 27 hours a week on average, and in 2019, this figure has risen to 28.5 hours. The percentage of women in employment is relatively high in the Netherlands. It was ranked 7th in the EU in 2019. The high rate of employment among women can be seen as the upside of the high rate of part-time work. There are, however, additional measures to encourage women to work more hours. For example, the research program, More Hours Work, focuses on removing barriers in the healthcare, childcare, and education sectors. Several interventions will be implemented to facilitate part-time workers that are able and want to work more hours in doing so sustainably. Also, the NGO Alliance, Financially Strong Through Work, informs employers how they can offer employees a full-fledged hourly contract. This alliance is set up to remove barriers for women in healthcare, cleaning services, and childcare to help women become financially independent in a sustainable manner. The difference in average hourly pay between men and women was indeed 10.5% in 2024. In 2010, the gap was 19%. The decrease of the pay gap in recent years was faster in the public sector than in the private sector. In order to further narrow the gender gap, the Netherlands took an active and positive position in the negotiations on the EU Pay Transparency Directive. The Netherlands is currently implementing the directive. A draft bill has been submitted for internet consultation to gather feedback from public and stakeholders as part of the legislative process. And the last thing, to further enhance the representation of women in decision-making and management positions, the Top Women's Act, Wet Ingroei Quotum en Streefcijfers, entered into force in 2022. It is too soon to draw conclusions on the effects of the act. Last year, the several Netherlands bureaus and universities studied the early effects of the act on gender balance on supervisory boards of listed companies. And in their report of March 2024, they concluded that in general, it had led to a better gender balance within the supervisory boards of listed companies. The share of companies meeting the quota increased from 34.5% to 81.7% during that period. So I'll give my colleague.
Yeah. We have 1 minute remaining, so let's see how far we get. Otherwise, we'll take it in the second part. So please continue.
Yes. Thank you very much. My name is Alexander van Wolraven of the Dutch Ministry of Justice and Security and Asylum and Migration. And I shall very briefly answer the question I believe was asked by the Honourable Rapporteur on the climate case of Bonaire. So to give you a short update, so the case was filed in January 2024 by Greenpeace and on behalf of Greenpeace and 8 inhabitants of Bonaire. Currently, the case has proceeded to the substantive submissions of the case, and in September 2024 this decision was made. That means that at the moment we're currently working on the submissions on both sides of the case, and the tentative hearings are scheduled for October 7th and October 8th. That's the very short update I can give the rapporteur on this, and I will give my floor the floor to the colleague.
Thank you. I think we have one colleague who wants to finish. So if you could conclude, thank you.
Yes. I'll shortly address a question on social security in Caribbean Netherlands. The social security system in the Caribbean Netherlands differs from the EU Netherlands. Although some social benefits and allowances are more or less similar in form, they differ in standards and norms. And at the moment, we are working on an equal system of provisions for Caribbean Netherlands. For example, on unemployment benefits and child-related budgets. Also, the height of the social welfare benefits in Caribbean Netherlands has been significantly increased in the last years. That's the short answer.
So I think I conclude for now. I think we've tried to address all the questions that were fired at us to our best of our ability. So I would like to get back to you, Madam Chair, and be in your hands for the continuation of the dialogue. Thank you.
Thank you, Your Excellency. We really appreciate the responses that have been provided to us to the questions raised under Articles 1 to 5 of our covenant. The idea of our interaction today is a constructive dialogue. We need to better understand how the state party is implementing its covenant obligations. And of course, we're very happy to get this additional information. It improves our understanding of the state party's obligations as well. So thank you so much. There are some very positive developments, but there are some where we express our concerns. So I hope you will understand that when there are concerns, we must share it with you. I will now, Your Excellency, open the floor for follow-up questions to the clusters. And I see that our country rapporteur and Mr. Mikhail Winfor have also requested for the floor. There are some others, but as well as Mr. Lazzari, Mr. Giuseppe Palmisino. I had a couple of questions as well. So I was just wondering that with the country rapporteur's approval, may I, since I have the mic, establish my privilege and perhaps ask questions, and then we'll go around the list. So just I have a few questions, Your Excellency. One was in the context of the justiciability of the covenant provisions, and our country rapporteur had asked specific questions on domestic implementation. So I wanted to ask that what specific steps does the state party intend to take to strengthen the justiciability of economic, social, cultural rights? And what are the arguments to exclude economic, social rights from the judicial review of your legislation, which is currently contemplated in the context of your constitutional reforms? That would be my first question. My second question would be really in terms of the natural resources, an area of concern about comprehensive human rights due diligence requirements of Dutch corporations, and how do you propose to strengthen this to ensure that the corporations' activities overseas do not harm people's control over the natural wealth and resources? That's part of your obligations as well under the covenant rights. I will leave it to our country rapporteur to further elaborate on the questions on the Bonaire issue, which has been, of course, responded to as well. On the issue of independence of judiciary, how does the state party have access to remedies? I mean, it's difficult for individuals to challenge the economic, social, cultural rights violations before courts. This is what we've been informed. So, and it is, there's no significant jurisprudence expanding judicial interpretation of these rights. So how would you ensure that these access to these remedies are provided? And the guides on the economic, social, cultural rights and constitutional review that exist. But however, we find that this is limited. There is limited evidence that they are systematically used by the judiciary or in their legislative drafting. So how would you propose to strengthen that? Then moving on to your business and human rights, a series of questions were raised and some response provided. But we find that as of now, there is only voluntary, there's no binding obligation really on the part of corporations. The government today relies more on a smart mix of voluntary and legislative measures, but this raises concerns about the enforcement and compliance of the covenant provisions when it comes to business and human rights. So could you throw some more light on that, elaborate a little bit on that? Coming to your monitoring and transparency mechanisms, the National Action Plan on Business and Human Rights exists, but the progress reports are infrequent and they're not integrated into the annual human rights reports. So could you throw some more light about that to ensure the monitoring mechanisms and the transparency of it all? There are concerns that remain about the equal protection of the cultural identity, heritage, and land-related rights of communities in Bonaire, etc. We'll be perhaps asking you more questions in subsequent clusters as well, but I thought I'll draw your attention to that. Moving on to one more important point that our country rapporteur had raised, and this is relating to climate and environmental policies, which are not really consistently integrated to human rights obligations, particularly in the Caribbean, Netherlands, etc. And she did speak about the common but differentiated responsibilities. And she highlighted the point about how it is incumbent upon the state party to provide both technology and financing. That is equally incumbent upon the state party when it comes to dealing with developing countries, and assisting them. So I wanted to know that, could you cite some examples of how, where they've actually assisted developing countries who have actually, been the biggest victims of climate change today, whether you have tried to provide any assistance and technology and financing to help them deal with the crisis of climate change? That's one. And then moving on to a related question was really on your official development assistance. And we find, and it is something of concern, that your official development assistance has actually decreased over the last 2 years. So really we wanted to know from you, what are the reasons for this decrease? And this reduction obviously impacts upon your development cooperation activities overseas. And is there any proposal to restore your official development assistance to the agreed UN targets of 0.7%? That was one more question. Then on the issue of transparency, we find that there are some gaps and that there's no comprehensive centralized public register of beneficial ownership for all companies. There is limited oversight of potential misuse of public funds and illicit financial flows. So what is being done to address this particular area of concern for us? And then on the anti-corruption measures that are dispersed across multiple agencies without a single national anti-corruption strategy, which explicitly links to maximizing resources for economic, social, cultural rights. So could you throw some more light on that? And finally, Your Excellency, you mentioned that you prepared your dialogue today, keeping in mind, of course, all stakeholders, including civil society. So we have received some inputs from civil society expressing concerns about Netherlands' participations in free trade agreements, both bilaterally as well as through the EU, where developing countries in particular have been put under pressure, which reduces their, their policy space, particularly when it comes to assuming obligations under intellectual property rights. For example, let me give you the example of UPO of 1991, which definitely, impacts upon the farmers' rights of poor developing countries. And so how then would you, because these are also part of covenant provisions as well, to ensure that preventing misappropriation of resources of farmers and their right to equitably participate in fair and equitable benefit sharing at the core of all negotiations around global governance when it comes to such agreements, that because finally, this is very much an important provision of our covenant rights as well. I'll stop here. But I've asked many questions, I know, but I will first start with Ms. Rossi, and then Mr. Winfor, and then Mr. Bouzid, Mr. Pamasano, Ms. Krachenia Tatu, and Ms. Perez. No? Okay. So please, Ms. Rossi, please go ahead.
Gracias a la delegación por la información.
Thank you, and to the delegation for all the information you have shared. It really is useful to us in shedding some light on the questions we had for you. I have a follow-up question on the justice system and domestic implementation of the covenant. It's not yet clear to me what status economic, social, and cultural rights have in the country. Are they really rights, seen as such when drafting public policies and programs? Or are they seen as rough guidelines or recommendations to be borne in mind? Then my second question, and here I echo the chair's question as well, about access to justice of people who see their economic, social, and cultural rights trampled upon. What means do they have to have their rights prevail domestically? And then lastly, the optional protocol to our covenant, can you provide additional information for why you haven't ratified it? It was signed in 99, but it wasn't ratified. You didn't conclude that, and we have not yet heard why. What is the argument for not concluding this process? And then on the criminalization of irregular migrants, are there alternatives to criminalization? Is there any political debate in the country to consider alternatives to criminalization? Or the majority of political parties, is there a social consensus around this option being the option for migrants? And there was also a recommendation to ratify the Convention on the Rights of Migrant Workers, recommendation 57 of our COBs. How do you explain the position that's counter to granting equal treatment to non-nationals who don't have legal residence under the obligations of the covenant and of our own interpretation, which is very clear about this? People in an irregular situation must be granted the rights in the covenant on an equal footing, in equal conditions. And then I have a question about information data production in Aruba. In the replies to the list of issues, you speak about developing a national statistics system based on standards to produce official statistics. What progress has been made in that system? How complete is it? Because it is very needed, especially for our covenant. We need to have more information, more data about the level of compliance with this international treaty. Thank you.
Rosie, I'll just give another 5 minutes to our questions so that we can take all the questions and you're able to respond to them collectively. Mr. Winfor, you have the floor.
Thanks, and thanks for the extra time, and welcome to the delegation. I would like to dive a bit more in three of the issues. The first one I will start with is international development aid. Our chair was already saying you had traditionally always above 0.7. You were to 0.62 in 2024, and your plans are going up to 0.42. So that would be, if I read the OECD statistics right, would be a cut by 1/3 of your aid. Yeah, it happens in the same time where the US is cutting all aid, UK is cutting aid, France is cutting aid, Germany is cutting aid. Where do we end with that development? Yeah, how do you discuss it at the European level? Who's taking care of humanitarian aid? There's no money left for Sudan for any shipment to this. Yeah, so the World Food Programme is losing half of its income. So just a reflection from your side. What do you think? Also, when it comes to the financing of the UN, yeah, the US is going down from World Health Organization, from other institutions. What is your plan, maybe also at European level, to address this? Yeah, we need stable support for these institutions. Otherwise, the multilateral system might become quite weak. Yeah, and your tendencies, at least as other countries, I don't see that is very positive at the same time. Secondly, concerning climate change, I have read your Netherlands Environmental Assessment Agency's report saying that the climate targets for 2030 are slipping out of reach because you are lowering achievements you want to have in climate mitigation. So I want to find out, what do you think about this, and if there's more encouragement to be possible or followed. And linked to this, I could also read that the international support for developing countries our chair was talking about is also reduced from 380 to 243 million. So maybe there's also why you are cutting this at the same time. So parallel to the development aid. I'm just asking this. Yeah. My last question is then on business and human rights, and great to hear that you have this collective action law, which is really, I think, a very good development. My question would be, what are the risks you foresee for Dutch companies at home and abroad in developing human rights due diligence? Yeah, so, and particularly, I know you have this very good functioning national contact point after the OECD multilateral guidelines. So what has been maybe some outline of cases you had at that OECD contact point, yeah, just to identify maybe the most important risk? And do you believe that with this weakened Omnibus 1 regulation of the European Union, you will be further able to address these issues properly? Thanks for that question.
Thank you, Mr. Winfer. Mr. Bouzid, followed by Mr. Parmisano. Mr. Bouzid.
Thanks, Madam Chair. Based on its obligations under our covenant, as clarified by General Comment 24, and also by the ICG advisory opinion on the Palestinian territory, is the Netherlands considering the option of imposing an arms embargo on Israel until Palestinian human rights are respected and Israel ends its occupation of the Palestinian territory and its genocidal attacks against the civilian population in Gaza? Thank you.
Thank you, Mr. Bouzid. Mr. Parmisano.
Thank you. Very briefly, I would like to insist on the situation of asylum seekers and so-called irregular migrants. Could you please provide us with information and positive examples showing that in the Netherlands, asylum seekers and migrants in an irregular situation of stay do actually receive adequate protection of their basic economic and social rights, including the right to housing and health care? And could you please inform us about the measures adopted, if any, to cooperate with other European countries concerned by the arrival of asylum seekers and others fleeing war, violence, famine, and extreme poverty in order to ensure temporary reception and decent treatment of such people? Thank you.
Thank you, Mr. Parmisano. And Ms. Laura Cracigna-Tatu, you have the floor, madam.
Thank you very much, Madam Chair, and welcome to the distinguished delegation of the Netherlands. I have a question which is related to your constitutional provision, Article 1 on non-discrimination. Although this provision indicates several grounds on which a person should not be discriminated against, and although in 2023 these grounds were expanded to include disability and sexual orientation, and although you have a part which states any other grounds, my question is whether are you considering, in light of recommendations which you received from several international institutions, to include socioeconomic background and ethnic origin as an explicit ground for discrimination? This is my first question. And the second question relates to the procedure in which a person which is affected by discrimination actually obtains redress within your legal system. So one less critique of the system was that for a regular person is quite complicated, that it is multi-layered, and that several institutions deal with anti-discrimination. So would it be possible to describe a bit how a person which is affected in her rights for, with discrimination can address the institutions in your country? So maybe the procedure would help to be to explain. Yeah. So what institutions are actually responsible for combating discrimination, and how a person can protect her rights against discrimination? Thank you.
Thank you, Ms. Krachiniotatu, Your Excellency. I'll now give the floor. Okay. Ms. Sharafat, yes, you have the floor. Sorry, one last question. Please go ahead. I'm sorry I didn't see it.
Thank you, Madam Chair. I may have a brief question about the action and the measurement that has been taken to fight against hate speech and discrimination from the political leaders, specifically against migrants, more specifically against Maghreb migrants. Thank you.
Thank you, Madam. Your Excellency, now you have 20 minutes to respond to the questions, and a lot of questions have been raised to you. Thank you.
Thank you very much, Madam Chair, and also thanks to all the distinguished members of the committee. As we were already expecting, you're asking us a lot of very pertinent questions. Some of them we were expecting, some of them we weren't. So we will again try to answer to the best of our abilities. But in the spirit of the constructive dialogue we are having together. Let me come back to the question on that I think that you raised, and that also Madam Rapporteur raised before, on the justiciability and the way we are invoking the rights in our domestic national order. So let me, to not make any misunderstanding about the value we attach to these rights. They are not just mere guidelines or vague elements that we consider when we are drafting laws. So our kingdom is bound by the treaty, and we are taking all efforts we can, and as I tried to explain in my former answer, improving the way we are integrating these the respect of these rights in our domestic legislative and policy-making process. So that was my first point. The second is, and there we might have a slight difference of opinion, or we might have a nuanced view on about exactly how this works out in the domestic national order. As I already explained, the way courts are looking at international human rights and assessing in the context of a specific court case whether the provisions of the international human rights treaty are binding on all persons, and that in practice so far they have applied them very scarcely in a direct manner. And I think in our assessment, this is due to the general wording of the provisions of the covenant that refers in general terms to social goals that impose on state parties, so on us, the obligation to implement them in our national legislation, rather than an obligation to confer rights directly on individuals they can invoke in a court of law. This is, in our understanding, because these rights have a more programmatic character and they necessitate legislative and other implementing measures by the legislator, and this also generally requires a political decision about the exact way how to do that, the resources to be addressed to that. So it doesn't mean that they are not respected, but it means that they are implemented in a way as a fundamental element of our national legislative process. I would invite my colleague of the Ministry of the Interior to later on in her intervention to briefly explain to you how this works in a practical manner when we are drafting national legislation. So perhaps that might clarify the way we are actually respecting these rights in our national system. You have also raised, Madam Chair, as the rapporteur before you, the question of the optional protocol. I would say, as I explained in my first answer, that we've been looking again at the optional protocols, and we have decided now to move forward with, in particular, optional protocol on disability. The brief, my brief rephrase of the whole title of the protocol. since that is very directly applicable and also really closely relates to a new action program we're implementing right now. And we want to learn from that process. And I cannot prejudge now what future governments will decide on the basis of the experiences we will be learning in the context of the application of that protocol. But to clarify a bit the background of our reasoning, we have asked in 2022, several ministers have asked the Dutch Council of State to advise on the consequences of ratifying the three optional protocols and thereby considering the nature and content of the protocols, the degree of ratification, and also the views submitted by European bodies and international organizations, including, of course, your distinguished committee. And well, I think the advice of the Council of State was thorough and diverse, but on that basis, the government has determined that the broad scope of the covenant makes it difficult and to in advance understand the consequences of ratifying it. And I would say that also relates to my first answer on the way we are implementing at the moment the rights under the covenant in our national domestic system, as I explained, through embodying them to really bringing them to the heart of our legislative process. But that is a different system than when you would organize a system where they would be directly invoked in a court of law. So that would really change that system. And for the moment, the government has decided that it's difficult to understand what consequences that would bear. And therefore, we have decided that we would start this process and focus on the more, I would say, focused protocol, if that, I don't know if that's a correct wording, but of the on the disability covenant. So I hope that answers your questions. I know maybe not on substance to what you would like to hear, but at least this is the reasoning that our government has taken on board. I think it was Mr. Winfour who asked a question, but not really sure. It went a bit close also on climate policy. Yeah, you were, because you were referring to the report of our environmental agency. Well, let me be very clear. I said in my first statement, we are still committed and to the Paris Agreement and also to the EU goals that actually implement the Paris Agreement. And we're currently having a discussion in Europe on how to set a goal also for 2040 to ensure that we will remain after 2030. This is the first goal, but after 2040, that we will remain on course to the 2050 goal. And in that discussion, the Netherlands is supportive of setting a strong 2040 goal so that it would ensure that Europe as a whole would remain on track. So we are certainly committed. But I wouldn't want to, of course, that is one thing. Of course, after that, you have to bring it into practice. And that is indeed a challenge. So I don't want to be, well, to brush that away. So we're actually seeing that some of the projects are taking off quickly, but others are not. That some of the policy measures are having also socioeconomic effects we want to take into account, also given, I would say, also in the context of the discussion we're having today, that you want to take environmental but also social and economic impacts into account. So the government is still working on that. And I'm sure that, as I said in my first statement, the next government will have to answer the question about what measures are we going to take to stay on course for the target. But I cannot prejudge now what new measures would be taken by the next government. There are 2 points points of order I would like to make now. There were, I think you asked some questions about illicit financial flows. I think we are not prepared to that right now, so I would like to see if we can bring it back tomorrow. And there were also some questions on trade policy. So my colleague will try to address part of it. If that doesn't answer the whole breadth of your question, then I would also ask your permission to come back to that tomorrow. So Paul, I would like you to continue on first, Marina. Okay, yeah, all right. Okay, yeah, so okay, I'm sorry, we're mixing up the order. I would first like to go to my distinguished colleague from Aruba to answer the question that was specifically directed to him.
Yes. With regards to the question on the national statistical system, Aruba has started making progress, first of all, starting at the 13th of December 2021, when an official NSS, National Statistical System, Commission was formed. This commission started carrying its work by first defining the the structure, the contours, and defining the actions that need to be taken. So the NSS, what's the idea is, it will be seen as more as a governance structure, where the Bureau for Statistics will act as a coordinating entity, which together with other relevant departments will manage a collection of data and the creation and the processing of data. The Commission has defined, stated it's important for new legislation to be drafted so that this system could be brought forward, could be created. Such a legislation should respect key principles such as independence, impartiality, objectivity, duty of care, clarity, coherence, relevancy, and as well as the needed care for the sensitivity of the information. Right now, apart from legislation, it's also the Commission has also defined that it's very important to have a code or more practical code on Rubis statistics on the way, so that there can be every department can be on the same page with regard to the norms that will govern the collection of data. Also, the importance on creating and developing effective databases, as well as developing a national strategy for official statistics, wherein transparency and independence are very important values. With regards to a concrete timeline, the implementation of the NSS will take place in phases. In the first phase, the following groups or statistics will be incorporated, will be within the new NSS. So by the end of October of this year, 2025, we will start with statistics with regard to population. And by the end of 2025, it will be more international statistics relating to international trade with regard. And these are the first subjects or categories of statistics of which we are currently in the process of integrating to the new national statistical system. I hope I have answered the question. And if I could add, I will very open to respond. Thank you.
Yes, thank you for those follow-up questions. I will answer the questions on business and human rights, development assistance, and arms embargo. Regarding due diligence and corporations' activities extraterritorially that could harm rights. In addition to what I said previously, the government also supports companies so they can conduct business in a responsible way in line with the UNGPs and the OECD guidelines. The Dutch Support Office on Responsible Business Conduct, run by the Dutch Enterprise Agency, provides information and helps companies with practical tools. And the Netherlands, as a distinguished committee member behind me also mentioned, set up the national contact points, the NCP, to familiarize companies with the OECD guidelines and how they can be applied. Regarding the observation of the distinguished chair on the non-binding nature of certain regulations and it being a mix of voluntary guidelines. As I mentioned before, under the EU CSDDD, companies within the scope will be obliged to conduct due diligence. So that is national legislation that will incorporate the directive. So that will be binding on the progress reports not being included in the human rights reports and being infrequent. The last progress report was from last year, 2024. It's true that the National Action Plan is not included in the annual human rights reports, but is included in the National Action Plan progress reports and in the reports on the results of development cooperation activities. regarding development aids, official development aids, a decrease over the last 2 years. The main aim of the Kingdom of the Netherlands official development assistance is the improvement of economic development and prosperity in developing countries. Since 1970, the Netherlands has been committed within the framework of the United Nations to the development aid agreements. It remains committed to the aim of 0.7% of GNI, and human rights remain a fundamental part of the Netherlands' development policies. In February this year, the Cabinet coupled development aid more to Dutch interests and the needs of countries with which we cooperate. And those Dutch interests include trade and economy, safety and stability, migration, and those interests are supported by programs focusing on water management, food security, and health. At the moment, the Netherlands, as mentioned by the delegation leader, has a caretaker government, and so discussions are ongoing, including in the framework of the OECD Development Assistance Committee. So that is the information that I can provide at this moment. Regarding the potential risks for Dutch companies at home or abroad, we would have to follow up to look at the OECD cases that the national contact point has been notified of. Whether the CSDDD will help, I will refer to the previous remark on it being transposed international legislation. Regarding the arms embargo on Israel, question of the distinguished committee member opposite, the Dutch government believes that the current arms export control policy is sufficient to prevent undesired exports of military goods. No license will be granted if a clear risk is established that military goods could be used in the commission of serious violations of human rights or international humanitarian law. Given the current situation, the Dutch government does not grant any licenses for the export of military goods to Israel that could contribute to activities of the Israeli army in the Gaza Strip or the West Bank. In practice, this means that currently the only active license with the Israeli Defense Forces as end user concerns the export of components for the Iron Dome air defense system. And I would like to hand over to the next delegation member. Thank you.
Yes, thank you very much. I shall be taking some questions on the justiciability of the convention and on the constitutional review. So for the first part, the manner in which the international law operates within the Dutch legal order is determined by Articles 93 and 94 of the Dutch Constitution. And pursuant to Article 94, someone can invoke the provision of international law before domestic courts when that provision is binding on all persons. And so it's up to the courts, to the domestic courts, to determine in specific cases whether such provision is indeed binding on all persons. That's a slight addition to what our delegation leader has said. And I believe that there was a question also on access to justice. I just want to clarify real quick that access to subsidized legal aid is regulated by the Legal Aid Act. And that people with limited financial resources can therefore qualify for state-funded legal assistance for any of the cases that they want to bring to the court. Now, to move on to the inclusion of social, economic, and cultural rights in legislation, we'd like to bring up that these are incorporated into manuals used in policymaking and legislative processes, such as the Policy Compass, Beleidskompas. And these compasses, they also include they ask specific attentions for compliance with economic, social, and cultural rights. And then it's up to the legal department of the Ministry of Justice and Security and the Ministry of Interior Affairs and Kingdom Relations to review exactly how new legislation coincides with conformity with fundamental rights. Lastly, there was a question on constitutional review. I'd like to mention the plans on constitutional review of the Acts of Parliament, because I believe a question was asked specifically on the non-inclusion of social, economic, and cultural rights. So we'd like to mention indeed that there was a legislative proposal submitted for consultation, and this proposal aims to overturn the constitutional ban I just mentioned on judicial review of statutory law as far as certain fundamental rights are concerned. At the moment, economic and social and cultural rights are not included because so far we have deemed that they are not fit for judicial review given the way our constitution is formulated. Because in these rights in the Dutch constitutions are framed as open norms which do not contain concrete obligations. So these rights require the government to make an effort to promote certain constitutional interests such as healthcare and the environment, and that makes the enforceability quite difficult. So given that they are leaving us quite considerable discretionary space, the Dutch government is of the opinion that it's difficult for the judiciary to engage in this act of judicial review, which would also infringe upon the division of powers between the legislative and executive branch on the one hand and the judicial branch on the other. If there are any other questions, I will be happy to answer them later, but I'd like to pass on the floor now. Thank you.
Left, so please be as brief as possible and we see how far we can get. Thank you.
Yes, I will try my best to be as brief as possible. So there were some follow-up questions on the criminalization of irregular migrants, specifically about alternatives to criminalization. So there are most certainly alternatives, which if the bill would be passed, always first need to be tried. So as this bill would only apply to people who have no legal right to remain in the Netherlands, the return process always comes first. So that's always prioritized, especially voluntary return. And even if the bill would be passed and someone would be convicted by a court, their return still takes precedence. So we really need to see criminalization as the last resort in this procedure. There was also a question about, let me see, about the adequate protection of asylum seekers and undocumented migrants. So regarding the rights and protecting the rights of asylum seekers in the Netherlands have the right to reception, which includes housing, meals, liability insurance, access to legal support and healthcare, recreational and integration activities, and education for minors. And this right is protected at all times, and we continuously work together with COA, so the organization that is responsible for the housing and the reception of asylum seekers, to optimize the accessibility of these rights. And for the healthcare of undocumented migrants, because healthcare, I think, was specifically mentioned in the question, the Netherlands is, in the Netherlands, illegal migrants are always entitled to medically necessary healthcare, regardless of their status, and also regardless of their ability to pay for the healthcare. Then I have another question on international cooperation. I don't know if there's enough time, but
After this call, I have two more colleagues who wanted to speak. So do you want us to continue or do you want us to do it at a later stage?
Your Excellency, maybe we can just complete. You
Yes,
could
we can?
complete, and then later in the evening, if we have time, you
Okay,
could respond.
right. Okay. Thank you.
yes, sorry. With regard to international cooperation, I can share the following. Cooperation with countries both within and outside the EU is essential for the Netherlands to address challenges resulting from migration. So, for example, being able to provide enough temporary reception. Within the EU, it's good to mention, of course, the Asylum and Migration Pact. And in this pact, EU member states have agreed on joint and legally binding arrangements to reinforce and reestablish common standards and mutual obligations. So the pact provides the Netherlands an opportunity to optimize asylum procedures with shorter processing times, so that would be a positive effect. And also outside the EU, the Netherlands works together with both governments and international organizations on mutual challenges arising from migration. And a flagship program in that regard is the Prospects program, which aims to strengthen economic and social inclusion of displaced people within their host communities. So that's all I can share.
Thank you very much. I know I'm aware that you have not been able to find the time to respond to several questions that were raised. But I hope that, as we go along, you would have that opportunity, Your Excellency. I thought if we could cover the questions today first, and then by tomorrow morning, perhaps you could devote some time to some of the residual questions that have been unanswered. So, Your Excellency, we'll now move on to cluster 2, which is relating to workers' rights, etc. And it is my responsibility to share with you our questions relating to the covenant provisions of Article 6, 7, 8, and 9. And I'll start with Article 6, right to work. And here, discrimination in the labor market is an area of concern for us, Excellency. According to research by the Social Cultural Bureau, Planning Bureau, nearly 1/4 of applicants face labor market discrimination, especially during the recruitment and selection process. Notably, non-EU citizens, particularly migrants from Syria, Turkey, and Morocco, face higher rates of unemployment, far above the national average. This problem is exceptionally high among asylum seekers and family reunification migrants. The predominant hurdle is the struggle to find stable and reliable employment. Job opportunities can be scarce, and if they are often out of reach due to complex interplay of factors, including legal restrictions, language proficiency, and cultural barriers. Consequently, many migrants find themselves trapped in a cycle of unemployment or underemployment, and they are unable to integrate into the labor market. The cumulative effect of these barriers affects personal livelihoods and hinders their broader societal cohesion and economic growth. Migrant women from minority communities are disproportionately affected, facing formidable barriers. Other categories that face discrimination include pregnant women, persons with disabilities, and age-based discrimination. So my questions are, Your Excellency, would it be possible to share some latest disaggregated data on the number of migrants and other categories, demographic categories, of the labor market share, etc.? That would be helpful. What steps, including legislative measures, are proposed to be taken to remove this discrimination in the labor market? How does the state party propose to cover the gap of the unused labor potential of migrant workers? My next question is, what measures are being taken to improve long-term employment rates and opportunities for non-EU migrants and asylum seekers to address disparities and inequalities, remove barriers of legal restrictions towards inclusive employment, language training, and other policies to improve job opportunities, and to create a more inclusive labor market? It, in a way, echoes Mr. Parmisano's question as well about what positive steps have you taken, and that will be helpful for us. A related problem, and we've talked about criminalization of undocumented migrant workers who are already in a precarious position. And that leads to, of course, resulting in human trafficking and their further exploitation. So what steps are being taken to protect the economic, social, and cultural rights of these undocumented workers? And since women are disproportionately impacted, with only 16% of refugee women that are employed 6 years after residency compared to 54% of refugee men, what measures are being taken to address this issue? Although Netherlands ratified the UN Convention on Rights of Persons with Disabilities face barriers to inclusive employment, administrative and structural challenges, and accessing disability-related social protection and adequate income support. So what concrete steps are proposed to be taken to address these barriers? I'll come to them in follow-up questions, as will our country rapporteur, Ms. Rossi. So I'll move on to other issues, and that is relating to Article 7, which is right to just and favorable conditions of work. Around 40% of workers are engaged in flexible or self-employed arrangements, including on-call and part-time workers. The state party, in your reply in para 16 of the list of issues, has not considered the large number of so-called pretend independent contractors who are supposedly without employees, that they are not covered by Dutch labor law. As such, their employers are under no obligation to pay into community health care for them, set up pension funds, or pay them if they get sick or disabled. Migrant workers in particular, as we've said before, are subject to greater abuse and exploitation. And a number of sectors, including construction, meat processing, agriculture, transport, and logistics are reliant on such cheap migrant labor, and we'd like to know more about that. The problems they face are severe and systemic and widespread. Unpaid or inadequate wages, higher poverty risk, unfair dismissal, unsatisfactory housing, homelessness, intimidation, higher risk of accidents and injuries at work, higher risk of exposure to dangerous substances, precarious contracts, etc. So I just thought I'd outline them. So my questions are, what steps are proposed to be taken to address the precarious conditions being faced by self-employed, on-call or part-time workers, including migrant workers? What measures are taken to ensure that companies do not exploit such workers using long and complex subcontracting chains to obscure employment relationships, circumvent taxes and social security contributions, avoid liability, and hide from checks by labor inspectors? Moving on to minimum wage, Excellency, you did share some figures that you've increased it, but while the minimum wage has increased, of course, so has the cost of living increased. And we were told in one of the briefings today that so has the profits of corporations. That is also, they've been the biggest beneficiaries as a result of all this. And so we were told that, you know, the minimum wage, and you said it's been revised, it still remains below social minimum. Correct me if I'm wrong. And estimated by unions is about 16 euros per hour, whereas yours is about 14 euros, unless it's been revised upwards. Moreover, youth workers earn significantly less for equal work. And a major issue is that indexation is calculated not on the basis of inflation or price rise, but it is based on collective labor agreements without taking into account annual pay increases. So my question is, what steps are proposed to be taken to address this problem? There are high rates of occupational illness as well. One of the largest causes of death in area of employment is on account of occupational illness. And so what measures are being taken to address the high rates of occupational illness and fatalities at workplaces? What measures are being taken to strengthen the capacity of labor inspectors to enforce safety laws? And what additional measures are being taken to combat workplace exploitation, especially of migrant workers, who often remain, whose cases often remain unreported? Moving on to Article 8, which is trade union rights. Union access to workplaces depends largely on collective labor agreements, and these are not legally mandated or guaranteed universally. Moreover, 71.8% of workers are covered by these collective labor agreements, and there's absence of legal provisions on access to workplace, most harshly felt in those companies and sectors that are not open to trade union interference as they see it, and are therefore less likely to have these collective labor agreements in place to give trade union access. An emphasis on freedom of contract places severe restrictions on the freedom of association and trade unions to protect workers' rights. So my question is, what steps are proposed to be taken to protect workers' rights in keeping with Article 8 of the Covenant, especially relating to collective bargaining, their freedom to choose bargaining partners, because the smaller unions tend to get marginalized in this context, and also in the right to strike. What is protected under Dutch law is, however, subjected to limitations, raising concerns over enforcement of strike-breaking prohibitions for employment agencies. And then, moreover, because higher courts often deem cases about the legality of past strikes inadmissible on account of the legal injury cannot be repaired, the strikes cannot in hindsight be held. This means that in practice, most jurisprudence in strike cases is adjudicated in summary proceedings by single judges who do not have to give a full motivation of their ruling. What steps are being taken to rectify this particular concern? And then finally, moving on to Article 9, which is right to social security, where our country rapporteur would have additional questions. My concerns relating the social minimum is below poverty threshold. Government has not implemented key recommendations to raise it. Moreover, we note that Netherlands still does not include large groups of immigrants and refugees in its social security system, which pushes this group further into poverty. Also, in terms of accessibility, the complexity of systems and digital barriers limit access for vulnerable groups, including people with disabilities, migrants, etc. So what steps are proposed to be taken to enable municipals to provide social security benefits in keeping with legislation? What steps are being taken to include immigrants and refugees in social security on an equal footing with other groups in Netherlands? And how is it proposed to cover the disparity gaps in benefits between European Netherlands and the Caribbean Netherlands? In the interest of time, Excellency, I'll stop here and give you the floor to respond to these questions, and you would have 20 minutes. You have the floor, Excellency.
Again, that's an impressive list of questions touching a lot of topics that colleagues are working on a daily basis. I'm going to directly go to some of the colleagues to answer the questions on their terrain. We've identified an order of speaking, and if any questions are remaining, I will see what remains that I would be able to fill some of the gaps. So I think I would like to go to the colleague of the Ministry of Security and Justice first. Justice and Security, sorry.
One second. Oh, yeah, yeah. Yes. So regarding the question on restrictions for asylum seekers to work, so previously, a few years ago, asylum seekers were allowed to work for a maximum of 24 weeks a year after a 6 months waiting period after arrival. And previously, your institute mentioned that this is an undue restriction of the right to work. So what we can share is that our Council of State concluded in November 2023 that the 24-week requirement is contrary to European law. And as a result of this, this rule was taken off the table. So this means that asylum seekers are now allowed to work all year round instead of just 24 weeks. So this means that a significant barrier for employers to hire asylum seekers has been removed. And of course, the right to work as outlined by the covenant is adhered to in regard to asylum seekers in a better way. And I will now give the floor to my colleague from Social Affairs.
Yeah. Yes, I think it's my turn now. My name is Casper Bada. I'm from the Dutch Ministry of Social Affairs and Employment. And I'm going to answer the questions regarding the conditions of migrant workers and also the undocumented workers. And I start with that. What do we do to better protect the undocumented workers in the Netherlands? Now, first of all, I have to agree that undocumented migrants are indeed more vulnerable to be exploited. And the government has strengthened the information provision for migrant workers in general, also available, which is also available for the undocumented workers. And the government has set up physical information points, and they're called Work in NL information points across the country. We have started in 11 regions, and next year we will be active in, across the country. So this is a major development we're making. There are also a website available, workinnl.nl, where people can find information about working and living in the Netherlands. Furthermore, the Dutch government funds the civil society organization Fair Work, and Fair Work helps undocumented migrant workers to claim their rights. By example, to claim their unpaid wages. Furthermore, what do we do to prevent labor exploitation? This is regarding undocumented workers, but more than also legal migrant workers in the Netherlands. We see that labor exploitation is taking place too many times. I mean, every single time that it's taking place is a single time too much. And now we have also a development here that the Dutch government is taking action to modernize the human trafficking legislation. So this is under the Article 273F of the Dutch Criminal Code. And the aim is to make the criminal law approach to human trafficking, including labor exploitation and serious harm to migrant workers, more effective, and to improve the prosecution of offenders and the prosecution of victims. So actually we want to create like a gradual scale so we can better prosecute the offenders and to make this more effective. Now, the new law creates more possibilities to protect the most vulnerable workers, such as the undocumented persons, and punish perpetrators who make advantage of the vulnerable position. Now, this bill will soon be discussed in the Senate. That will be this autumn, if I'm not mistaken. What are we doing for the better enforcement? The Netherlands Labor Authority also has a major role in the better enforcement. We are strongly committed, of course, to combat the abuses, and the enforcement is an important role to avoid or to tackle abuses that are taking place. Now, I have to say, first of all, that we expect the admission system that we will introduce for the temporary work agencies in 2027, that will have a great effect also for their better enforcement in this sector. So in the temporary work temporary work employment agency sector. Sorry, it's a long word. And in the meantime, because this has taken a long time, there was a commission in 2020 with all recommendations to improve the situation of labor migrants, which we are implementing. We expect this in 2027 that we can introduce this, but in the meantime, the capacity of the Netherlands Labor Authority is expanded with 90 FTE for the admission system and 25 FTE for enforcement on temporary work agencies in general. And also for the criminal criminal investigations unit of the NLA, the Netherlands Labor Authority, as I said, has been increased with 30 FTE. And lastly, I think that is also relevant to mention is that also the fines of the NLA have been increased recently. So the fines will be significantly higher because they will be indexed retroactively. The fines have not been adjusted in recent years and are expected to increase by approximately 18% per violation. So from now on, the amounts will be indexed annually. With this, we also want to more effectively tackle abuses that are taking place. Then I give the word to my colleague. Yeah.
Thank you. The labor market discrimination question. The statistics regarding labor market discrimination show little improvement. For example, the number of discrimination cases at the Netherlands Institute for Human Rights was 670 cases in 2022, 520 in 2023, and 621 in 2024. Part of the action plan on labor market discrimination was the implementation of the Equal Opportunities in Recruitment and Selection Supervision Bill, Wet Toezicht Gelijke Kansen, that required employers to have an objective recruitment policy and which gave the labor inspection more supervisory rights on this matter. This bill passed the House of Representatives. Unfortunately, the law was not passed by the Dutch Senate, just by one vote. With the not passing of the before-mentioned bill, the focus has shifted from legal measures to stimulating and supporting employers on creating equal opportunities through the offensive on equal opportunities, offensief gelijke kansen. The government funds diversity in company, part of the Social Economic Council, to support this effort. The offensive focuses on regional initiatives, such as the creation of local diversity boards. This helps employers in battling labor market discrimination and developing diversity and inclusion policy. Research shows that employers are mostly influenced by each other, especially within their own region. Therefore, the diversity in company has created local diversity boards in several regions. The offensive also focuses on creating tailor-made tools on objective recruitment for sector organizations. It is hard to pinpoint exactly what the impact of the action plan is on the labor market participation of different social groups and minorities, due to the fact that discrimination usually happens unconsciously, and it's hard to pinpoint what kind of effect policies have on this. Nevertheless, there are some insights to be found. For example, the labor participation of women has increased from 76.6% in 2020 to 79.5% in 2023. Labor participation of people with a disability stabilized between 22 and 23, with around 50% of this group having a job. Special attention has to be given to the labor participation of women with a disability, which is 57% compared to 65% of men. This shows that there is still room for improvement. The offensive on equal opportunities will continue the activities with relevant stakeholders from the action plan in battling labor market discrimination. Then moving on to the minimum wages. The Ministry of Social Affairs is responsible for balanced income development. If needed, the government takes measures. These measures may include tax rates, tax credits, allowances, minimum wage, and/or state pensions. After several increases over the last year, the government will ensure that the minimum wage remains stable. There has been and will be regular indexation of minimum wages. Research will be conducted into the effects of decreases in 23 and 24, and results of that research are expected in 2027. And then the last one is about labor unions. Access to digital to workplace. Such facilities are ensured through social dialogue, where government, employers, and workers' organizations negotiate and consult, for example, through collective labor agreements. One of the advantages of ensuring facilities for workers' representatives like access to the workplace through CLAs, collective labor agreements, is that contracting parties can deliver tailor-made arrangements befitting the circumstances of the workplace in the industry or enterprise. The government has come to the conclusion that although in general it goes well, there is room for improvement. Given the current situation, there are still possibilities for social partners to achieve this. Therefore, the government has recently requested social partners to realize agreements on access to the workplace in more CLAs. In turn, central organizations in the Labour Foundation have announced that they will ask the central contracting parties to make arrangements for access to the workplace. The government will look into the situation, the arrangements in CLAs at the end of 2027, and dependent on the outcome, the Netherlands will reconsider further actions. The freedom of association and contract is paramount in the Dutch collective bargaining system. A party that wishes to conclude a collective labor agreement must be authorized to do so by its articles of association. This is checked by the government when parties register the collective agreement. In the Netherlands, there are no legal requirements imposed on the parties that conclude a collective labor agreement. Therefore, the required information can be provided. The Dutch government is in conversation with the social partners about the CLA system to see if and which measures are necessary to strengthen the system and legal framework. There are 4 pillars to this discussion: improving the level of organizations of both employers and employees. Second, ensuring the independence of labor unions, including right to form trade unions. Third, updating policy rules concerning the extension and exemption of collective labor agreements. And fourth, lastly, improving the coverage of CLAs. This year, the government will inform Parliament on the progress made on these pillars. Then the right to strike. I'll try to be short on this one. It is possible for trade unions to appeal against strike bans. Parties can initiate summary proceedings regarding collective actions such as strike. A decision of the court of first instance can be appealed to the Court of Appeal and subsequently to the Supreme Court. Of course, because of the time involved, the ruling by a higher court will be relevant primarily for future cases. Trade unions have to decide whether they want to submit a decision to the Court of Appeal and subsequently to the Supreme Court. The judge will then have to determine whether a case is admissible or not. Thank you. I'm not sure. There.
Thank you. I will shortly address the question on the complexity in the social security system, especially the accessibility for migrants and in the Caribbean Netherlands. At the moment, we are strengthening the Participation Act, the act which provides people who cannot work or who need social support, social benefit. We are strengthening it with the program Participation Act in Balance. With this program, which includes legislative action, we aim to reduce long-term reliance on social assistance. That means reducing unnecessary rules, so simplification, providing more room for tailor-made solutions by municipalities, and making sure benefits do not stand in the way of stepping into work. In essence, it's putting the people for who it's meant more central, to put the needs and their talents more central. So it's simplification in a Dutch way. For specific measures such as the intensification and improvement of the strategy on non-use, we do have specific attention to reach hard to reach groups like migrants. We do this by putting extra effort in reaching them through key stakeholders and, for example, informal networks, religious networks, and experts by experience. On Caribbean Netherlands, I refer to what I told before. We are working on an equal system of provisions for the Caribbean Netherlands as in Dutch, the EU Netherlands, for example, on unemployment benefits and child-related budgets. Also to simplify and the benefits and make it more accessible in the Caribbean Netherlands. Thank you.
Thank you. I think there are no colleagues currently on the floor who want to take the floor. Otherwise, I will take some of the remaining questions. Yes? Okay. I think we also, Madam Chair, you asked a few questions on our policy, I would say, on occupational safety and health. I would like to inform you that our ministry, in cooperation with the other ministries, has established a new OSH Vision 2040, I would say. And the goal of that vision is to reach a zero death goal in 2040. I think it's fair to say that that is an ambitious target, but somewhere that is that we really want to try to achieve, and therefore we've updated all our OSH policies. Also looking at international standards, of course. I think it's good to note that the ILO has, of course, increased its number of fundamental conventions, and that we have also, as the Netherlands, last year, or I think beginning of this year, we've ratified the last OSH convention, so that we have ratified all the international fundamental conventions of the ILO, in particular also on OSH, so that we can improve our policies in that area in line with international standards. Some of the measures we are taking in this regard is I would say the essence of the strategy is a stronger focus on prevention. So that means that we are expecting from employers that they have a proper policy in which they identify risks and they evaluate risks, and this is a continuous process where they have a strong responsibility. We strengthen enforcement, and I think my colleague already explained the increases of our labor inspectorate over recent years. Still, they are stretched because, of course, they have a lot of work to do, but we've increased them in several areas, including focusing on migrant workers, but also generally on improving OSH standards. We are working to try to improve the number of occupational doctors in companies. And we are also working in the context of the European Union to increase norms, for example, the use of toxic substances. We've already quite relatively high standards in the Netherlands, but for some areas we're still increasing them, and we're also trying to do that in the European level so that we reach a maximum impact. Second question, maybe briefly, I think to add, my colleague already addressed the issue of the minimum wage, and you asked for well, you asked for how does it relate to inflation. Of course, there are many numbers that can be compared there, but I here have the numbers that look a bit to a longer period of time, back to a longer period of time, from 1998 to 2025. So over the last few decades, the gross minimum wage has increased 14% in real terms, so that compensates for inflation. And for example, gross model wage has increased by 6%. So minimum wage has been catching up, I would say. But as my colleague explained, this is a continuous process. We are regularly evaluating the correct level, and there we're also taking into account the European directive that was adopted, I think 2 years ago, that sets a framework to assess the height of the level of the minimum wage. Lastly, on my part, and then I'll check if we're a bit ahead of time, so maybe we've missed some important issues, but I think you also asked about the high level of self-employed person in the Netherlands and their position. I can confirm that. We have had, I think it's already maybe a little bit longer ago, sort of a broad commission that looked at the future of the Dutch labor market and that has proposed several reforms. After that, in the good dialogue of the good tradition of the Dutch model, we have agreed with social partners on a reform agenda for the labor market, and that includes measures, for example, to provide more security for people on a flexible contract. It also includes ending systems where people have a 0-hour contract, so that they have more security about the hours that they can work. And it also includes other measures to reduce the difference sometimes being perceived in the labor market between self-employed workers and fixed contract workers, for example, by introducing a compulsory, trying to find the right word in English right now, disability insurance for the self-employed. So that proposal for law is already in Parliament, or will be in Parliament soon. I think it first needs to go to the Council of State. Is it? No? Really? Okay. It has to, I think last week then, right? Yeah, last week it has been sent to Parliament. So this is not a complete picture, but just to say that we are working on addressing some of the disparities in the labor market, and we hope that will also improve the rights of some of the people who have a more vulnerable position in that labor market. Checking with my colleague. Sorry, Esther. Yeah, another one moment, please. The Ministry of Asylum and Migration would like to.
Sure, please.
I'm sorry, I'm struggling with the microphone. There was also a question on social security for asylum seekers and refugees. So specifically for asylum seekers, there are multiple facilities and social security measures that are applicable to them. For example, the right to reception, right to legal assistance, liability insurance, and also an important one, the right to healthcare. So for a medical care, we have a specific medical insurance for asylum seekers. And this is nearly the same healthcare package as the basic package provided to all Dutch residents under the Health Insurance Act. And this is free of charge for asylum seekers and organized by COA, so the organization that is responsible for the reception of asylum seekers. And then we have the municipalities who are responsible for public health care for asylum seekers. And once an asylum seeker becomes a refugee status permit holder, they have access to the same package of social security like healthcare benefits, childcare allowance, and housing allowances as all Dutch residents have. Yes.
Any other colleagues who would like to take the floor? If not, I think I missed, at least to my recollection, I missed one question you were asking about, maybe more, but you will tell me. One question you were asking about long chains of subcontracting, and I think my colleague more or less answered to that, but I just wanted to, at least the way we are trying to improve labor standards, for example, for labor migrants, also when there are cross-boundary effects. I would like to add that we're also within the European Union, as we're having a free movement of workers. This is an issue that we're also pushing there. So we're trying to work for to have our labor inspectorate cooperate with labor inspectorates in other European countries, also under the umbrella of the European Labour Authority. And we're also asking the European Commission to come up with proposals that will clarify the status, for example, of third country nationals that are allowed in a certain European country and are then seconded to another European country. This kind of constructions in principle could be legal, but they can also be vulnerable to abuse. So we're, as one of our priorities in our European policy agenda, we're trying to come up with proposals and convince the European Commission that we need a clarification in that area to ensure that we can better enforce the labor rights of everyone who is involved in such a construction. That being said, you asked a lot of questions. We've been brief, relatively brief, but we might have missed something and others might have something to add. Thank you.
Thank you, Your Excellency. Thank you for providing these details. Perhaps you've missed out a few questions. Some remain unanswered, but you assured me that tomorrow, when there's time permitting, you will definitely be able to respond to some of those, some for which you definitely have asked for more time. So we look forward to your responses. As you will appreciate, our concerns really stem from the fact that, you know, these particular articles of our covenant really on right to work, right to just and favorable conditions of work, right to strike, form trade unions, etc., stem directly from the covenant provisions. And we are naturally interested in ensuring that the state party, there are some very fine examples and your responses have been very good. But of course, you know, our concerns stem from your obligations of conforming to and implementing the covenant provisions. Excellency, the floor, I will now give the floor for follow-up questions. We'll devote 10 minutes to our follow-up questions on cluster 2. And after that, we will take a call whether we should move straight on to taking questions from cluster 3 to enable you, or maybe give you a brief chance to respond. But at the moment, the floor is open for questions on cluster 2. And I recognize Ms. Ju Yong Lee, followed by Ms. Julieta Rossi. Ms. Lee, you have the floor.
Thank you, Chair, and thank you, distinguished members of delegation, for constructively engaging with us in this dialogue. I would like to ask questions which concerns primarily the right to social security, but it also concerns Article 2.2, non-discrimination, and also Article 15. We heard from the delegation that the state party acknowledges systemic discrimination in social security. We are concerned that the state party's deployment of automated surveillance and fraud detection in relation to social security benefit administration has produced systemic discrimination against individuals and families on the basis of socioeconomic status and migration background. We note that the SYLI, the system used by tax authority, was found unlawful by the National Court and has been hurted. However, it is not an isolated case. Similar algorithmic profile has been used by municipalities and by the Education Executive Agency, DUO, in student benefit checks. We are particularly alarmed by the routine use of proxy variables such as neighborhood, income, family composition, language proficiency, and other socioeconomic markers, which correlate with the migration background and effectively target disadvantaged groups. These practices demonstrate the systemic algorithmic discrimination in the administration of Social Security and benefits. Please explain what measures the state party has taken to suspend, review, and remediate any automated profiling used in Social Security and benefits administration. And specifically, what steps has been taken to prohibit or restrict the use of proxy variables that correlate with the socioeconomic disadvantage or migration background? My last question is also related to Article 15 of the Covenant in a more broad sense. How will the state party ensure that the AI, automated decision-making and algorithmic systems used in public administration do not replicate or reinforce structural discrimination, and what immediate safeguards, independent oversight, and remedies will be put in place? Thank you.
Thank you, Ms. Lee. Ms. Rossi, you have the floor, please.
Muchas gracias.
Thank you very much, Madam Chair. I'd like to thank the delegation for the information provided. By way of follow-up questions, I'd like to ask about migrant workers in an irregular situation or who are undocumented and whose rights are not met. Can they make a complaint to the administrative authorities, or can they make a complaint before the judicial authorities? So that's one aspect. And secondly, can you give us some information about the demographic makeup, which the chair of the committee was referring to, of irregular migrants, asylum seekers and refugees? So could you give us a breakdown of the origins of those people? Could we ask the chair to turn her mic off, please, so we don't get interference? Thank you. I've got some question now about the employment of persons with disabilities as a vulnerable group. So what specific measures have you taken to bring down barriers faced by persons with disabilities, and how do you close the gaps in regional results on employment with persons with disabilities, and how do you meet the targets or ensure the targets are met for inclusive employment, quotas, and do you have supervisory mechanisms to ensure that municipalities meet their obligations on participation of persons with disabilities in the labour market? Do you provide support to low-income regions, and is there long-term monitoring, and what measures have you taken to ensure that there is inclusive recruitment? Do you provide financial incentives to employers that provide accessible workplaces which are sustainable as well for persons with disabilities? And what measures do you take to ensure there is equal access to employment for all groups of persons with disabilities? And how do you tackle the extra barriers faced by women with disabilities in accessing the labour market? And do you mitigate the use of biased algorithms in recruitment processes? And how do you ensure that there is meaningful participation of persons with disabilities in drafting labour policies? Persons with disabilities face significant economic hardship because social security benefits, as we were saying, tends to be fragmented and it's complex. There are some systems which provide income support, but on other occasions, support is insignificant. So how do you ensure that there is appropriate economic support for persons with disabilities that enables them to meet their basic needs and reflects the real cost of living with a disability? And lastly, what's the situation in the Caribbean Netherlands concerning access to disability benefits? And I wonder if the representative from Aruba can provide us with some general information about the social security system in Aruba. And I'll leave it at that for now. Thank you.
Thank you, Ms. Rossi. Mr. Winfer, you have the floor.
Thanks, Chair. And I feel tempted to discuss with more in details if these rights can be applied individually or only as policy measures. But maybe we can propose to have a meeting of our working group on communications with you, looking into specific cases, how we deal with these issues and how easily right to housing and other rights might be become applicable on individual rights. Yeah, and maybe this is a proposal we can take with us, yeah, because I think it deserves a further discussion. But I'm not going into the details. Just coming back to the cluster 2, thank you for describing how much you are investing to reduce maybe flexibility or the insecurity of flexibility in the labor market. My question would be, does it has reduced the people in extremely flexible working conditions? And also, what does it mean when more forms of platform economies and others are at the same time increasing? So how do you see the future of this, let's say, flexibility jobs, which are very high in the Netherlands, and giving also these tendencies, yeah, which are there in the labor market, platform economies? My second question would be how you assess the future impact on artificial intelligence on the labor market. Yeah, will it increase more flexibility, or what are your prospects of maybe where do you have to make sure that workers are let's say trained enough to deal with this sector? What are the sectors particularly hit by this? And my last question on flexibility is, do you plan, or what are your discussions on flexibilizing maybe the going into the pension age, a discussion which is in many European countries also ongoing? What are your thinking about flexibilizing, let's say, the work hours or the work times of people maybe beyond 65, 67, what you have, and how to deal with this by also making sure that there is no, let's say, risk for health and this coming up. What are your plans on this respect? Thanks.
Thank you, Mr. Winfer, Your Excellency. Although we've planned 20 minutes for your responses to these follow-up questions, may I suggest that we just take 10 minutes today and then the balance can be done tomorrow. We'll take 10 minutes now and then we'll stop to request Mr. Peter Zimuse to share his questions on cluster 3 so that you'll have the time overnight to prepare for your responses. And of course, you'll have that extra time to respond to the follow-up questions as well. So my request is 10 minutes and then we stop and then take questions on cluster 3. So 10 minutes, you have the floor.
Proposal, I think that's very welcome. If we could have an update on the questions we'll be answering tomorrow, I'm sure that we can increase the quality of the answers even further. So that would be great. There's one, at least on one issue, you asked a question about the demographic composition of several groups. I would first propose that we put that question tomorrow in any case, because it is a bit more wider question and it requires us to compare some statistics. So that being said, I would like to go to my colleagues, and I think I will start with a colleague from Aruba for the specific question to his ask to him. Is that okay, Javier? Or do you want to be later? Later? Okay. I'm looking at my app. Which was the next one? Yeah. Okay. Please, the colleague working on, I would say, poverty-related issues in a broader sense. Thank you.
My mic is on, yes. On the issue of disability and social security, the Dutch government constantly tries to improve the labor market for people with disabilities, especially for people who need a sheltered employment due to their disability, and that's quite successful. In 2021, municipalities only realized 79% of the quoted sheltered workplaces. In 2024, this was 96%. So we expect that municipalities realize 100% of the quoted sheltered workplaces in 2025. Not all municipalities do realize their part of the sheltered workplaces. Dutch government stimulates this by raising the budget for sheltered work, changing and simplifying the way an employer receives a working subsidy for a person who needs a sheltered workplace, improving social infrastructure through regional plans and transformation budget, and make administrative agreements with the Union of Dutch Municipalities. For people with disabilities who can work with less support, there's the job agreement. This agreement was made in 2013 to create 125,000 jobs for people with an occupational disability. Since 2013, 90,000 jobs have been created for this group, which is behind the 2026 target. So in order to better achieve the target group of the job agreement will be expanded in the coming period. This will enable
you.